Welcome to the inaugural Pocket Chat sponsored by the joint Chicago Bar Association, Chicago Bar Foundation Task Force on the Sustainable Practice of Law and Innovation, or SPOLI, as it's affectionately referred to. I'm Mary Ann Mason. I am Secretary of the Chicago Bar Foundation and co-chair of the task force. With me today is my friend and co-chair, Lynn Grayson, a partner at the firm Nyman and Franzetti, and the first vice president of the Chicago Bar Association. Lynn and I are so pleased to have with us today Jayne Reardon, known to many of you as the executive director of the Illinois Supreme Court Committee on Professionalism. Jayne is a nationally recognized expert in all issues regarding the legal profession. And we are so grateful to have her on the task force and to have her with us today in our inaugural Pocket Chat. So thank you for joining us, Jayne.
Thank you for having me, Justice Mason and Lynn. It's been a pleasure serving on the task force, and I'm really pleased to be here for your first Pocket Chat.
So let me start by asking you, Jayne, about the prevailing state of affairs in the market for legal services. Where are we right now?
We are in the middle of a maelstrom. The landscape has been shifting and changing over the last several decades. But where we are right now is a situation where we have a very complex, legally complex society with statutes and laws and regulations and ordinances, very complex, and yet individuals do not seek out legal help in resolving and understanding their rights, resolving their disputes. There's a lot of complexity there that lawyers could help with. Yet at the same time, we have lawyers under and unemployed looking for clients to help navigate the legal system. There's a disconnect, a market failure here. We do have a situation also, as we all know, the world has become more technologically advanced. Technology can help with a lot of the tasks and problem solving that confronts individuals and lawyers. But unfortunately, our attorney regulations stand in the way. Some of the recent studies say that lawyers only, especially those who represent individuals and small companies, only spend about 20% of their working day on billable work for clients. The rest of the time they're spent doing administrative tasks, trying to figure out how to configure technology and looking for clients. So we have people who desperately need legal services or could benefit from them. We have those able to provide those services, but some institutional barriers to getting them to connect up. Some say that the regulations, the rules of professional conduct, some of them are the part of the problem here. And I think this task force and others have taken that head on to study that issue as they should.
So you mentioned other task forces. We're aware that Illinois is not the only or the first jurisdiction to attempt to deal with these problems. And I know that you have been involved on a nationwide level in addressing these issues in other jurisdictions. Could you give us a thumbnail sketch of what other jurisdictions are doing to address these problems?
Yes, sure. As a member and the chair of the ABA Standing Committee on Professionalism, I've become involved over the last decade or so. And I'm also a member of the Association of Professional Responsibility Lawyers, Future of Lawyering Committee. We've been looking at these issues on a national basis, attempting to rejigger some of the rules and make some recommendations as appropriate. But really, I'm very heartened that over the last 18 months or so, there's been an incredible growth and momentum in a state-by-state way around this issue. As you know, the state Supreme Courts decide the rules of professional conduct, and they don't vary significantly from state to state, but there is quite a bit of variance. But we have about 6 or 7 states that have established task forces now, including Illinois. And I'll just mention a few that are kind of out ahead of us. Last year, Utah came out with a task force report that its Supreme Court has already moved into the implementation phase. Utah has recommended that certain rules of professional conduct that govern lawyers be amended. Specifically, the rule, it's called 5.4 under the model rules. Almost every jurisdiction has that. It says lawyers cannot share fees with non-lawyers. Non-lawyers may not invest in law firms. Utah is suggesting that rule be modified and allow outside investment and allow the sharing of fees. In addition, they're making some suggestions of changing the marketing rule, which Illinois is as well. Rule 7.2 in particular prohibits lawyers from accepting monies for referrals. And that has been not very consistent with the way things operate right now. Some of the ethics opinions have said joining a platform is sharing of fees, therefore it's an ethical violation. So that's a real chilling effect as lawyers try to reach out with their services. So Utah is underway with those. They've got a proposal out. They're asking for comments through July 23rd. The other innovative aspect of what Utah is doing is they are bringing under the regulatory umbrella the law companies and non-lawyers who are also delivering legal services. Right now, all of the state Supreme Courts only regulate lawyers, and we know that the practice of law has become a kind of vague term now when websites are offering products and services online and they may or may not be offered by a lawyer. So they're looking at taking everybody providing legal services under the regulatory tent. They have what's called a regulatory sandbox in a pilot phase, and they accept different companies, services, and products into that sandbox. And the idea is it's impossible to prognosticate 3 years down the road what a good regulation in this setting would be. So they're going to develop systems in conjunction with various companies, gather the data, make sure that there's constraints and protections for the clients on it, and then figure out phase 2, what should be the regulation going forward. So that regulatory sandbox is a unique approach in the legal profession. Apparently it's been used for a number of years in financial services and other professions. Arizona is also out in front with its task force recommendations have been out for public comment, and the Supreme Court is going to consider those next month in August. They have similar suggestions about easing Rule 5.4. In fact, their recommendation is to eliminate the rule, to allow lawyers and allied professionals to go into business together. And here's a unique twist to the Arizona approach, to regulate the entity. Right now, if a lawyer works for a big law and there's an issue, an ethical violation, even though that lawyer might not have directly set in place the systems or what have you, the lawyer is the only one who's on the hook for ethical violations. We don't regulate law firms under the current system, except New York does, but Illinois does not. Most states do not. So entity regulation is under consideration in Arizona. They're also considering a limited license along the lines of the licensed limited technicians in Washington State that operated for a number of years but now have been disbanded. But a number of states are saying, it seems like some legal services could be offered by a professional short of a full JD, similar to what's done in the medical profession. Let's explore a less expensive, more nimble paraprofessional licensure to still protect the public and get services out there. So Arizona is looking at that as well. I'll just mention one more state, California. Also had a very lengthy task force report and recommendation, and they have in their implementation phase now they're considering a limited license type licensure as well. And they also have established a working group to look at the issue of whether or not there should be a regulatory sandbox for legal companies delivering services in this area. So those are the three states that are out in front. There's some other states that are moving along as well, Connecticut, New Mexico, and a couple of others beyond Illinois. But considering most of this has happened in the last 2 years, it is fairly rapid development.
It sounds like there's a lot of creative thinking going on out there. I have to say, a couple of times when you were talking about Rule 5.4, you mentioned non-lawyers. And I don't think there's any other profession that refers to people outside as whatever they are, non-doctors, non-accountants. And I liked your use of the word allied professionals, because really I think that's what a lot of states are exploring. What other professionals can lawyers partner with to deliver legal services? So let's focus for a minute on Illinois and the circumstances here as they compare to those other jurisdictions you just mentioned. What's our status?
So let me just first address the non-lawyer thing, because you caught me and I share your chagrin.
No.
No, but it is true. We lawyers are the only profession who defines who's in and everybody else as non, which is not particularly helpful in the complexity of today's practice, when we desperately need the assistance of technologists and people who understand predictive coding and analytics and project management and business. So unfortunately, the rules say lawyers, non-lawyers, so it's inculcated in our culture. But I think you're absolutely right, and I try to say, if we're going to have a collaborative, reimagined profession that is serving the public to the best extent possible, we want to talk about how can lawyers and allied professionals join forces in service to the public. So I agree with you wholeheartedly. And you asked me about Illinois. Illinois mirrors a lot of the other states insofar as the fact that we have dropped the number of civil case filings. For example, in the last 20 years, in Illinois, the case filings have dropped 30-some%, 40-some% since 2009. At the same time, the number of people represented by lawyers in those cases is plummeting. The number of self-represented litigants as of 2015, according to our Access to Justice Commission, it was about 50%. And in some matters like family, it was up to 80% of those matters, at least one party was self-represented. And interestingly, The National Center for State Courts did a study in 2015, and it said that the average amount at stake in the state courts is under $5,000. So you can understand why lawyers, when they have all of these other overhead expenses, don't find it profitable or sustainable to represent those individuals. The other interesting thing about Illinois, and I don't think we're an outlier here, I know New Mexico and other states have put out some studies that are similar. Our geographic distribution of lawyers is extremely lopsided. We have 102 counties. Half of them have not admitted a new lawyer in the last 5 years. 16 counties admitted no attorneys over the last 5 years, and 50% admitted fewer than 5 attorneys over the last 5 years. So we have a system built under the assumption that 2 lawyers are representing 2 parties in a court, and all the rules around the procedures are built on that assumption, and that assumption hasn't been true for 15 or 20 years. So we have a lot of tension and waste, frankly, in our system. Our resources aren't being spent the right way. And I think what I'm reading, our experience is that of other states. The pandemic has exposed the fractures and the weaknesses of this system in ways that really make it imperative that we address this immediately. It is expected that there will be a tsunami of a need for citizens to have their rights adjudicated, evictions and consumer debts, domestic violence, etc., whenever we emerge from this global pandemic. So there will be an increased need, and it's clear the system as currently constructed is not adequate to address that need.
So I don't want to monopolize this conversation, Lynn, and I'm going to throw it over to you.
So Jayne, the last comment you made, I think, is a perfect jumping off point. Given everything you've shared with us and the current state of the legal market, how do you feel like the task force that you're a part of, and you're such an important part of, plays into these nationwide efforts and what we can do here in Illinois to make the changes that are necessary to make sure that lawyers have a sustainable practice and access to justice is a reality for everyone that needs it?
I am really optimistic and heartened by where Illinois stands. First of all, we have an incredibly forward-thinking court. You might remember that Illinois was the first state to establish proactive management-based regulation a few years back, PMBR. And that's a mental shift from we must discipline lawyers when a client complains to we should train and support lawyers to have ethical infrastructures in place. So the ARDC here in Illinois has put on its website, free to all lawyers, a 4-hour training that is proactive and supportive. All the lawyers who do not have malpractice insurance must take that training, but anyone may and receive CLE credit for it. I'm pleased that we put a segment in there on civility and professionalism. But that demonstrates a huge shift, and other states are exploring PMBR as well. Our court also has in place a 3-year strategic plan built around the principles of fairness, accountability, integrity, and respect. And what fits in that is the entire work of this task force is how can we be more fair, more accountable, more respectful of the citizens of our state. And our Supreme Court is demonstrating their commitment to that. As you may know, I'm sure you know, but the Conference of Chief Justices and the ABA passed resolutions just in the last year urging state Supreme Courts to do what Illinois and some of the others have, which is consider regulatory reform to allow lawyers to better serve their clients while making sure there's protections in place. So with that backdrop, I was so impressed with Bob Glaves and you, Justice Mason, and Lynn and Jess in the setup of the task force, the establishment of guiding principles, saying, number one, the current status quo is not acceptable and sustainable, where we are serving so few of our state citizenry and our lawyers trying to serve individuals are struggling financially. So if there is a part of this problem being contributed by our regulations, ours being, we're a self-regulated profession, we have the obligation and the moral duty to look at changing them. So the task force work was incredible, and I think we were able to do so much so quickly because we didn't have to reinvent the wheel. We looked at the other, especially those 3 states that were out in front of us, considered what they did, would it apply in Illinois, and then put our own analysis on it. And there were 5 distinct committees with a real cross-section of practicing lawyers from various areas of law and across the state. So I think the Illinois report is really solid, and I'll be curious to see where it goes, but I think it's going to push the national dialogue, and I think it's going to make our profession better for those in it and those we serve.
That would be a perfect place to stop, but we've got a few more questions. Thinking about what you've said and thinking about the work of the task force, what are some of the key areas of regulatory reform associated with the report you've seen so far and the recommendations? What are you most interested in, and what do you think is most important given what you've seen from the task force so far?
So, Lynn, I come at this from professionalism, right? Which is we can always strive to do better, whereas regulation is what is the minimum floor we cannot accept anyone falling below, because we need to protect the clients and the people we serve. So there's so many things that are great about the report, but one of the things that I took great pleasure in rereading it and during our work was the very careful way in virtually every committee meeting, we went back to the guiding principles. What is the objective of regulation? What are we trying to accomplish? And there's a line in the preamble to our rules of professional conduct, which I think is really important. And that is the profession has a responsibility to ensure that its regulations are conceived in the public interest and not in furtherance of parochial or self-interested concerns of the bar. So I've been doing a lot of thinking. I'm writing a piece right now on what does that public interest mean? And we have focused in our regulatory scheme on we can't harm our clients. True, absolutely true. But don't we have an obligation to consider our client base is shrinking by the year, by the day? And isn't there a wider public interest? And so there's 2 public interests here. And that is the public interest in the rule of law and the administration of justice. No other profession has obligations in that philosophical, really foundational aspect of our constitutional democracy. And I think our regulations have to reflect that we must protect the rule of law and the administration of justice. And I'll tell you, and I'm sure you will agree, it's been an eye-opener the last 4 or 5 weeks, because it is clear the public does not respect the rule of law or the administration of justice. So we have our work cut out for us, and it's imperative that we consider the focus of attorney regulations with that in mind. I don't know that that's the primary public interest, but it's a very important one.
Jayne, we couldn't agree more. The last 4 or 5 weeks, as you point out, have really brought to a forefront several different things that are at the heart of this task force, how important legal technology is when it comes to law. And I think you hit the nail on the head. The rule of law is a critical issue that perhaps not everyone appreciates its central focus and importance in our democracy. So I appreciate your comments in that regard. These are extraordinary times that we're living in. With that being said, before this report goes to the Illinois Supreme Court, you appreciate that we're hosting a public comment period. Can you give us a little insight and your thoughts on that public comment period and how people can share insights and feedback with us if they're interested in doing so?
Yeah, I'm so glad that there's a public comment period, and I urge people to please spend some time with the report and do some deep thinking on this. Those of us who have been involved in the task force have been living it, but it takes some time and some deep thought to really reimagine what the legal profession could be and why these recommendations are being made. Please take the time to provide detailed comments, and if you have alternatives, bring them forward. You know, there were a lot of people on this task force, but there's many more lawyers and allied professionals and citizens of the state of Illinois, and we really want people to weigh in with thoughtful, in-depth comments. That makes a difference. It makes a difference in every one of the task forces down the road, or that are considering things. Right. So please do that, and then I understand that there will be a reevaluation of the report in light of the comments, and maybe some modification before recommendations go to the Supreme Court. So I think this is a really critical issue at a really momentous time. So I hope a lot of people will weigh in and give their perspectives. You know, there's a lot of different approaches already out here amongst the states. So it's not like only one approach can be made. We do know that what we have in place right now can be improved on, and we have the obligation to improve on it. So I hope everyone will weigh in.
Right. Jayne, we can't thank you enough for all of your contributions to the task force and for joining us on our first Pocket Chat. We're happy to have the opportunity to work with you to do what you like to say, reimagine law, and make sure that it's better for all of us. Do you have any final comments or thoughts you'd like to share with us that you've not been able to contribute?
No, I just want to thank you both for your leadership. It's been a privilege. You put together an incredible task force, and I'm really very honored to be part of it. So let me know how I can help you in any way.
Very good. Thank you. Justice Mason, anything else from you?
And thanks all around. Great conversation.
Okay. On behalf of the Chicago Bar Association and the Chicago Bar Foundation, we'd like to thank you for viewing this very first Pocket Chat and your interest in our work of the task force on the sustainable practice of law and innovation. We invite you to visit the Chicago Bar Foundation website at chicagobarfoundation.org to learn more about the final report and the recommendations to be submitted to the Illinois Supreme Court to modernize our rules of professional responsibility and make the legal market better for everyone. We invite you to view additional Pocket Chats related to other task force recommendations, also available on the Chicago Bar Foundation website, and share your thoughts and feedback during the upcoming public comment period. We look forward to your participation. Thank you all again.